Good afternoon. Before we begin, please join us in a moment of collective silence in remembrance of the events of September 11, 2001. On that tragic day, we witnessed unmatched heroism by firefighters, police officers, medical personnel, and ordinary citizens. The court system lost 3 of our own that day: Officer Juergens, Captain Harry Thompson, and Officer Mitchell Wallace. We honor them for making the ultimate sacrifice. As I call the calendar today, please ask for the time that you actually need, and remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have a chance to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you're requesting. We have 7.5 hours of argument time requested, which obviously we're not going to be able to provide you, so keep that in mind as you ask for the time for oral argument. First case is People versus Jean-Baptiste.
Good afternoon, Your Honor. Appellate requests 6 minutes and 2 minutes.
Give you 5 and 2 and 5. 2814 Morris versus Ortega.
Appellant requests 5 minutes, 2 minutes for rebuttal. 5 minutes, 2 minutes for rebuttal. 7 minutes, Your Honor.
4 and 2 and 4. Our serenity is submitted. Warner Media Direct v. Paramount Global. Five minutes. 5 and 2 and 5. Ramos versus Ford Foundation.
Appellant requests 4 and 3. Respondent requests 4 minutes. The respondent 4 minutes, Your Honor. The respondent sells it 2 minutes.
I'll give you 4, 3, 3, and 3. Oh, 4 and 3, counsel. You asked for 3 on rebuttal, correct? So 4 and 3, 3, 3, and 3. Thank you. Rodriguez versus FGI Corporation. You seem to have no opponent. Would you like to be heard anyway for some short period of time?
Does the court have questions?
I think we're fine on submission if that suits you. Okay. So Rodriguez v. FGI will be submitted. People v. Gordon. Submitted. Costanzo v. American Academy of Dramatic Arts. Did you want any time in rebuttal, counsel?
Yes, 2 minutes.
Okay, I'll give you 5 and 2 and 5 and 2. People v. Kyle Hardison. Submitted. Halgene Watch v. Alex Capital Fund. Submitted. Vasquez v. New York State Office of Children. Okay. We'll go with 4 and 2 and 3 and 3. D. Sandy v. Lewis G. is submitted. People v. Isaiah Rivera, submitted. People v. Michael McNeil. 5 and? I'll give you 5 and 1 and 5. People v. Balby, submitted. People versus Christopher Maldonado, submitted. E-Trade Bank v. Del Valle. You don't seem to have an opponent. Do you want to be heard?
3 minutes then, Your Honor.
3 minutes it is. People v. Carrasquillo.
Skip Foley.
Oh, I'm sorry. Which did I miss?
Foley.
Oh, Foley, of course. Foley versus New York City Board of Elections.
4 minutes, Your Honor.
I'll give you 4 and 2 and 4, and I'll take this case first, so you'll be heard first. People v. Carrasquillo, submitted. Beals v. Roman Catholic Archdiocese.
Appellate request 4 and 1. Respondent request
4 and 1 and 4. Bodenchak v. 5178 Holdings is submitted. Connie versus New York City Health and Hospitals is submitted. New York Life Insurance v. Hancock Life Insurance is submitted. So we'll begin with Foley. Please step up. You stand there, Mr. Foley, and the microphone does pick up your voice, so. Please. Okay, please proceed, Mr. Foley.
Good afternoon, Your Honors. My name is Joseph Foley. I'm pro se, and I'm here. I have 4 minutes and 2. This is an urgent case for Board of Elections. I believe the Board of Elections already certified the ballot for District 2 this morning. I don't know what court can actually change that right this second. I've tried to find out, but the only Court of Appeals could fix agency. However, if this can be fixed here with answers for future elections, it would be great, because the core of the arguments are very simple. Jurisdiction is first versus fairness. Jurisdiction is the predication. Affidavit is a very simple legal term. An affidavit is a sworn testimony. An affidavit is a sworn statement that cannot attest to an event that has not happened, and that is exactly what has happened here. It's not legal. Election law 6153B requires service on or before the date of filing with proof of service.
You know, Mr. Foley, the Board of Elections has said that there is a facial deficiency in your petition, which they're allowed to attend to. Yes. And that is, of course, that you use the word families in your independent, whatever the title is. So could you respond to that?
Yes, I can respond to that. They had objections previously on May 22nd with the name apostrophe S families. That was approved for me to move forward to be heard and have that, and was submitted with numericology of each signature of the pages, pagination. Those 2 aspects are, and they were cured with a printing error and numerology. And that was on May 22nd, both letters. So they gave up.
Are we talking about the same thing, sir?
Yes, I am.
The difference between NY Families First and Working Families Party?
Yes. So basically, there was a printing error that said possessive. I can't even explain this in 4 minutes. Possessive families, and essentially they gave up that right when it went to general objections. And so basically the simple is that the agency gave up and the public had to challenge my signatures. Those objections came in general aspect and then therefore were sent after the aspect, meaning the service was sent after the affidavit was after this affidavit was submitted. So on its face, they don't have jurisdiction to even look at this after they already gave that up. Secondarily, everybody in this room understands that 24 hours are in a day, medical, sports, every aspect. And she is right, there is no law with case law that says that's 144 hours, but it's stringent when it comes to the candidates. When you have a witness and go get petitions and signatures, you can have hundreds of signatures. And if that witness forgets their own zip code, that entire page is void. It's hyper-technicalities for the candidate, but not the objector.
Mr. Resto, there is case law which let me start again so you can hear me. There is case law that indicates fraction of days in computing time periods are not to be considered unless the hour itself is material to the resolution of the competing claim. So I know we're speaking of the 144 hours. And my question to you is, how is that time frame material with respect to resolving this issue as to whether or not the Board of Elections should have validated the designating petition, particularly since there are two violations here. One, which is noted in the decision, you cannot use New York or an abbreviation, and certainly that was used, as well as NY, Families First. And once again, we already have a party, the Working Families Party. So can you answer that?
Please.
Yeah, okay. Again, it's jurisdictional. It doesn't get to that aspect at all because they already gave up that as agency and it went to the general public for objections. And so going back to the words family and what you're saying about the 144 hours, it was after the fact and the BOE has a timestamp by the minute when they submit it. Again, that objector also put an affidavit of service that was fraudulent and lied about sending service to me. In addition, that
Thank you, Mr.
service...
Pohl. You have time on rebuttal. Please.
Good afternoon, Your Honors. Susan Paulson on behalf of the Board of Elections in the City of New York. Your Honors, the Board's invalidation of Mr. Foley's independent nominating petition was correct as a matter of law. The Board has an independent obligation to determine whether or not there are any facial defects on the petition. And here, due to the...
Can you respond to the statement that you waived, that somehow the Board of Elections waived that defect?
Yeah, this wasn't an argument that he presented in his brief, and I'm not exactly sure what he's referring to and what's in the record that would indicate any such waiver. And as far as I know, the Board can't waive the facial sufficiency of a petition. Under the election law, the petition has to adhere to certain substantive requirements of form, of having the name of the candidate, the district which they represent, the party name, et cetera. There are certain facial requirements, and I'm not aware of any law that allows the Board to waive its right to rule on those facial defects on the petition. Your Honor, the alleged jurisdictional defects are academic because of the facial insufficiency of the petition, and in any event, they're without merit. As Your Honor pointed out, there is, and as my adversary concedes, there is no law that establishes that you count the within 6 days as a matter of hours, not days. And there is no fraudulent affidavit of service that I saw on the NYSIF docket in the record. What is in the record is a FedEx receipt that establishes that service was made on or before the date of filing, which was June 4th, and that service was made to the proper address in the proper form by overnight delivery. It certainly would not be a jurisdictional defect in any event as long as service was made and there's no fraudulent affidavit that would make that notice of service improper.
Counsel, as to the name of Mr. Foley's party, NY Families First, thank you. Is there an opportunity to correct a name when there is a mistake?
There is not an opportunity because the signatures have already been collected with that party name, and to the extent that there may have been voter confusion with another existing party due to the overlapping party name, the party name cannot be changed. The signatures would all then be invalid. They would have to go back. So that is not a curable defect. And the court, the Second Department held as much in the D'Arresto case, which is cited in our brief. Your Honors, I would ask that the decision below be affirmed.
And I just have one final point.
Yes, Your Honor.
In your brief, you cite Furlong versus Haight. That stands for the proposition that even in the absence of an objection, the board has a statutory duty independently to determine the validity of a petition, correct?
That is correct, Your
So
Honor.
even if the affidavit of service was not valid and the objector was thrown out, which is what he's asking that be done here, you still have jurisdiction to determine the validity, correct?
That's correct. That's why we argue that these alleged jurisdictional defects are academic in any event. We argue that they are not defective, but in any event, it doesn't matter due to the facial insufficiency of the petition.
Thank you, counsel.
Thank you very much.
Thank you. All I see right this second is that I have more signatures than the primary candidates had votes. And the Board of Election, for some reason, is trying to get me off the ballot. I do not know why. I have valid signatures, and this is over the word family. 99% of these people in this room, if put Working Families Party and New York Families First, would be able to tell the difference. That's number one. Number two, they're just backpedaling because that affidavit of service is a lie, straightforward. They said they sent this service, but they filed the affidavit of service before. It was an hour and 27 minutes after the fact. Furthermore, I wasn't even served. My lobby was served. I found it in the lobby 2 days later. The fact remains is very simple, is that I have valid signatures. People want me on that ballot. Thousands of people for this district. And what BOE is doing right this second is basically taking that right away from voters across this district too, that is an open seat right this second. And any point, as much as the politics and news has been saying with electoral law, right now is the most important time for elections. To take away the voice of people that want me on the ballot to get me a chance to vote and change the way politics are, they're just saying, oh, because of families. But the fact is they did not have jurisdiction. And that still remains, is that they're saying this is academic. You can't have laws all of a sudden to say that you have an affidavit. That is a lie, that they already sent it, that happened in the future. That is on its face lawless, right? So if you have an affidavit of service and then 2 hours later you actually send it, it happened in the future. So right there, that's a fatal defect on that part of that objector. She's saying this is academic. It's just not. They're just trying to backpedal and not get their decision. I have no idea what will happen with this court, but I ask you to put myself back on the ballot. Thank you.
Thank you very much. Thank you both. People v. Jean-Baptiste. Please.
Thank you. Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Gustin Jean-Baptiste. There was not adequate justification in this case for Mr. Jean-Baptiste's attorney to reveal to the court that Mr. Jean-Baptiste had told him that he knowingly possessed a gun and was willing to lie
The
about it.
revelation by defense counsel, was that in any way prompted by the trial judge?
No, it wasn't, Your Honor. So what happened in this case was Mr. Jean-Baptiste asked for a new attorney. There was back and forth with Mr. Jean-Baptiste, and counsel was given an opportunity to be heard. The court definitively rejected the motion for substitution of counsel. Only after that was complete did Mr. Jean-Baptiste's attorney ask for the opportunity to make an additional record. Of course, the court permitted counsel to do that, but that is not the same.
Well, also, wasn't it the case that that the court had some colloquy with Mr. Jean-Baptiste where it looked like Mr. Jean-Baptiste was going to be excluded from the case, from the trial, being present?
Yes, Your Honor. Mr. Jean-Baptiste, after the court denied his request for substitution of counsel, asked the court to voluntarily absent himself from the courtroom. And after a full colloquy, the court agreed. And crucially, that colloquy included a warning to Mr. Jean-Baptiste that he would not be permitted to testify if he was absent from the courtroom.
So the statement that was made by counsel to the court would have been relevant had the defendant been able to or elected to testify.
I think that's right.
Well, you know, let me take that back, because typically what happens is, it's my experience and understanding, that if a defense attorney is faced with the ethical dilemma where they anticipate that their client is going to take the stand and not be truthful, the attorney has an obligation to inform the court, right? But that is usually done by saying, I can't examine him. He or she will testify by narrative. And the universe knows what's being said without making the admission that the client of privileged information.
Yes, Your Honor, and a few important points there. The Court of Appeals cases, Andrade, Appellate, they say the perjured testimony has to be imminent, right? And here, that just wasn't the case. Mr. Jean-Baptiste wasn't in the courtroom.
And by his choice.
By his own choice, following a colloquy where he was warned he wouldn't be able to testify. And even if his testimony had been imminent, it was not in this case. Counsel just went too far. What the cases say is you can disclose that your client intends to commit perjury. That's not privilege, but not the details of privileged communications. And here, that admission that my client told me that he knew he possessed a gun just went way too far and went beyond what the
So the disclosure of that privileged communication, that in and of itself creates a conflict.
That's right, Your
There's
Honor.
no need to show that there was some sort of prejudice.
No, there's not. And that's especially true in this context because I think what counsel was doing, it's pretty clear given the timing, was responding to Mr. Jean-Baptiste's request for a new attorney. That Mitchell line of cases says where an attorney takes a position adverse to his client, just as counsel did here, substitution is required. And so Mr. Jean-Baptiste is entitled to reversal of his conviction and a new trial under the circumstances. I would also just point out there was no need for counsel to further respond to the motion for substitution of counsel because, as I said, it had been definitively denied at that point.
Counsel, if I may, now certainly defense counsel volunteered to make an ex parte record. And he pretty much explained that for strategic reasons regarding the duty of candor and ethical obligations. Once that happened, am I correct that the trial court then asked him to confirm whether that strategic decision included not to cross-examine the police officer?
That's right, Your Honor. So after Mr. Jean-Baptiste's attorney had revealed this highly damaging information, the court asked for clarification really of a separate issue and said, well, look, why didn't you cross-examine that first police officer? Counsel explained. I think the fact that that issue was so separate is significant because that's really what prompted Mr. Jean-Baptiste's request. And the disclosure of perjury just wasn't responsive to that request. Thank you.
Thank you. You have time in rebuttal.
Thank you.
Good afternoon. Sarah Lubin for the People. Counsel's disclosure in this case was appropriately tailored to maintain his client's confidences as well as
Counsel, how were defense counsel's statements not premature, given that it wasn't clear that the defendant would testify?
So at this point in the trial, defendant had left the room. Counsel had asked to make this sealed record. Additional witnesses had testified, and they were now up against the lunch break. And the only portion of the trial remaining would have been defendant's testimony had he chosen to return and testify. So given that at this point in the trial, defense counsel had already been told multiple times to find out whether his client might be returning to testify, and was already making this sealed record with the judge, it does make sense at this juncture that he would choose to also explain to the judge that his client would need to testify in narrative form if he did, given that had defendant chosen to return after the
Why
lunch.
offer a why?
Pardon me?
Why offer the court a why, a reason, what, details as to why his client wouldn't testify? For me, reading this, it was almost like classic, ethics, professional responsibility, criminal procedure clinic at school. How do you get around that?
So if I understand the question correctly, you're asking
Why offer additional details when they were unnecessary?
So first is that the fact that defendant is going to commit perjury, that perjury is not a protected confidence. There's also the fact that in this case, there's only...
Wait, when you say it's not a protected confidence, you're saying that the defense attorney was under an obligation to tell the court the admissions that the defendant made to his attorney that were privileged?
No, and he is very clear that he's not disclosing what his client is saying. He's very clear that he's not disclosing what the content of the testimony would be. It's the fact of the perjury.
But he could have he could have alerted the court to the fact of the potential perjury in ways that did not include divulging to the court what his client told him in confidence.
In this case, though, and this is sort of my second point, is this is a case where the only charge in the indictment is criminal possession of a weapon in the second degree, and knowledge is really the
Would
only...
it have been sufficient for defense counsel to say, Judge, he intends to testify, I cannot help him in this regard, and that's it?
That would have been appropriate, or that would have been sufficient. However...
So he went the extra mile here. He disclosed what the client actually said. Didn't that create an actual conflict?
No, in this case, it did not. That this disclosure was still limited enough that it did not create a conflict.
Limited? It's the whole thing. It's an admission of guilt.
It is, but under these circumstances where counsel does not explain anything about what the testimony is, does not go...
I'm sorry, but didn't he tell, the lawyer disclose that his client told him that he had an understanding about the gun and the ammunition and thinking it would, because it wasn't in the gun?
That is part of the conversation he has.
So that's what he told the court.
He tells the court that his client has admitted to him that he knew that he possessed the gun and that they had had conversations, and this sort of dovetails with...
But it was not just to possess the gun, that I had the ammunition in the gun, but he had a certain understanding that if the ammunition wasn't in the gun, he wouldn't be liable for this particular crime, putting the Hunter Biden issue aside.
Yes, that they...
So isn't that a conversation, as my colleague pointed out to you, that was privileged, that he told the court that he didn't have to tell?
In this case where defense counsel was also responding to defendant's outburst that led to him leaving the courtroom, and that in that way these two issues sort of dovetail, is that defendant makes a lot of allegations as he's about to leave the courtroom. Defense counsel sort of asks to make this sealed record and begins explaining some of what he believes is relevant to this motion for new counsel that defendant has made, but then does say that I can't go further with the prosecution in the room. Justice Mandelbaum says, is it true that part of this is related to your decision not to cross-examine, and then agrees that he should make this sealed record. And then as soon as defense counsel does start making that sealed record right before the lunch break, he does initially dive into explaining some of the allegations that defendant has made before leaving the courtroom.
Counsel, let's go into the transcript. Phillips stated, if he wants to testify, he can, but he will have to testify under a narrative. He has admitted to me he possessed the gun and the ammunition knowingly, and I had to explain to him that it is not a defense. The magazine with the live rounds were not inserted into the handgun. I mean, I could keep reading. How much more specific can you be about a client confidence? This is not a situation where the defendant said to him, I have a gun and I'm going to use it right now in this courtroom. We're not talking about that. We know that an attorney absolutely has to say something at that point. This is something different, isn't it?
It is, however, the Court of Appeals has approved of cases where defense counsel has disclosed something about what that perjury would involve, or what their client has disclosed to them, pointing to DePaulo specifically, where counsel discloses that his client has admitted that he was present at, I believe it was the scene of a homicide. In this case, while it is true that he perhaps could have stopped with, I can't assist my client or I can't question my client while he's testifying, the disclosure here was vague enough that it did not create a conflict with his client. Seeing that my time is up.
Justice Moulton, may I just pose a quick question? Here, can you tell us why disclosing the client's guilt, why didn't that exceed defense counsel's factual explanation as to the efforts that defense counsel took on behalf of the defendant? Why didn't it exceed that factual explanation?
I think that the two are related, that he's giving this factual explanation about sort of his side of why his representation has been appropriate and adequate. And part of his explanation is that there has been disagreement during his explanations of why this is criminal possession of a loaded weapon as opposed to something different, even though the ammunition is not in, or the magazine is not actually inserted in the frame of the firearm in this case. So the two are related or interwoven. If there are no further questions, we will rely on our brief.
Thank you, counsel.
Counsel, if I may. This was a jury trial and not a bench trial. Did that make a difference in the sense that the judge was not going to be the ultimate trier of fact?
Not under the circumstances here, Your Honor, because defense counsel's statements didn't just prejudice the judge as fact finder, but also created a conflict of interest, an active conflict of interest between Mr. Jean-Baptiste and his attorney, which required substitution of counsel. I do just want to make a note about timing. We take very seriously counsel's obligation to disclose to the court perjury when it's imminent, when there's going to be a fraud on the court. But when counsel asked to make this application, it was immediately after Mr. Jean-Baptiste had left the courtroom. Had he had a conversation with Mr. Jean-Baptiste over lunch where Mr. Jean-Baptiste insisted, yes, I'm going to perjure myself, of course, counsel would have been obligated to make a more limited disclosure than he made here, but to make some sort of disclosure. That's just not the case here.
Because actually, it can be, let's say, fair to say that when that disclosure was made, neither the court nor defense counsel was aware that defendant was planning to testify. It was only after this additional conversation that defense counsel then knew regarding the defendant's intent to testify.
That's exactly right, Your Honor. And of course, Mr. Jean-Baptiste had told the court he understood that he wasn't going to be able to testify, and then he didn't testify. So that is strong evidence that it was not sufficiently imminent that Mr. Jean-Baptiste would carry out a plan to commit perjury. If there are no further questions, we'd ask the court to reverse Mr. Jean-Baptiste's conviction. Thank you.
Counsel, before you sit down, you were assisted on this brief by two law students, is that correct?
Yes, and
Emily Dinan and Jonathan Coaxum?
Yes, and they both were fabulous and provided invaluable assistance to me. I'm very grateful for their help.
We thank them for their work and also for you, your mentorship of those students.
I very much appreciate that. Thank you, Your Honor.
Thank you. Thank you both. (2814) Morris versus Ortega. You want to stand by the lectern, counsel. Thank you.
May it please the court, Anthony Jackson of Ginsburg and Misk for the appellant. I've spoken with respondents' counsel, and we are aware that this matter has been thoroughly briefed, and we will cede our time for questions, if there are any.
Okay, so you don't want to have oral argument?
I mean, if the court has any questions, we're more than happy to answer them, but we don't believe that it will assist the court in any way to continue to belabor the same points that have been made repeatedly.
Okay, any questions? Thank you. Thank you both.
Thank you.
Thank you. Okay, the next matter is Warner Media Direct versus Paramount Global. Please.
Good afternoon, Nari Kim for Appellants Paramount Global and MTV Entertainment Studios.
Counsel, could you pull the microphone a little closer? Thank you.
Second.
That's better.
So in this unjust enrichment claim, respondent Warner Media says that Paramount unfairly profited by streaming South Park content that Warner
Counsel.
Media says it was
Counsel.
entitled to.
Would you slow down a little bit and speak louder?
Yes.
Okay, bring the mic down.
So in this unjust enrichment claim, Warner Media says that Paramount unfairly profited by streaming South Park content that Warner Media says that it was contractually entitled to under the written term sheet. The parties and the Supreme Court all agree that the unjust enrichment claim would be barred if the written contract covers the dispute. And respectfully, the Supreme Court and Warner Media are a bit confused as to what it means for a written contract to cover a dispute. Now, there are three common formulations that New York courts have developed over time. One asks, is the dispute within the scope of a contract? A second asks, is the subject matter of the dispute covered by the contract? And a third asks, is there an independent duty that arises independently of contract that the plaintiff has identified as being violated by the defendant?
Now, counsel, does it matter that Paramount and MTV were not signatories to the contract?
I don't believe it does. There is overwhelming authority, and the most recent authority out of this court says that that shouldn't be a distinction that matters. There's 20 plus cases that have been cited in our brief, including the First Trinity case, which was issued in May of this year out of this court, that says that that is no longer a distinction that should matter. There's also a Second Department case, Akia versus Villa, that came out in April of 2025 this year, that explains very comprehensively why this distinction should no longer be a factor. And in that case, the court details that it should always be a question of whether the plaintiff is bound by the contract. And if the plaintiff is bound by the contract, it shouldn't really matter who the identity of the defendant is. Because if the plaintiff is barred by the contract, that contractual bar should activate as to that plaintiff, no matter who the party is. So even if there is a split of authority in the sense that there might be 20 plus cases that say the distinction doesn't matter, and I believe 4 cases that Warner Media has identified that go the other way, it is certainly not an even split of authority. There's beyond the numerosity.
You also have the argument that the claim is duplicative of the tortious interference claim, correct?
Correct.
And that tortious interference claim is directed at Paramount, is it not?
Correct. So that is a second
You want to
independent
unpack
basis.
that? Yeah. Why don't you talk about that for a moment?
Sure. So the tortious interference claim in this case says that Paramount engaged in misconduct by diverting South Park content away from Warner Media in breach of the term sheet. And that is exactly what the unjust enrichment claim says as well. It says Paramount engaged in misconduct and diverting content away from Warner Media, and it did so by inducing a breach of the term sheet. These are mirror image facts. There's really nothing other than the enrichment element, which isn't enough to make a claim non-duplicative. And for that reason, that's a separate ground for recognizing that the unjust enrichment claim shouldn't proceed in this case.
We're dealing with two provisions. I believe it's the term sheet, Section 3, that's the license material, correct? Yes?
Correct.
And then, and that's specified. And then we're dealing with Section 8D. So it's really fair to say, really, we're just looking at an interplay between the term sheet, Section 3, and 8D. And if it's not licensed content, then everything falls within Section 8D.
That's exactly right. And Section 8D is something that is unique to our case and not present. There's no clause like that, for example, in the Joseph Sternberg case that does a lot of work in the Supreme Court order. There's no provision that acts as this kind of catch-all net for all content or all rights that don't fall within the scope of the license rights. That is something that I think distinguishes our case from the plethora of cases that might find that something falls outside the scope of the contract. In this case, it's impossible for content to fall outside the scope of the contract because 8D acts as the backstop that ensures anything not within Section 3 falls within Section 8D.
Thank you, Counsel.
Thank you.
You have time in rebuttal.
Good afternoon, Your Honor. Georgia Winston from Weldon Mockton Heron for respondent. I just want to follow up on something that Ms. Kim said when she first started speaking. She said that respectfully that the Supreme Court and we were confused regarding what it means to be covered by a contract. And I think that gets to the crux of the issue here because appellants make a lot of arguments, but they're kind of boiled down to the same point or the same theme. And their essential position is that the scope exception here should be read so broadly that it effectively subsumes the exception in its entirety. In their view, that scope exception, meaning if the contract covers something, if the contract touches on something in any way, whether implicitly or explicitly, then it's covered. And I think that is different from what the cases say that are relevant here, Sternberg and Union Bank, and I think JLO Development and a couple of others that we cite in our brief, which is that if there is a dispute about the scope of the contract, or if, as here, the contract is ambiguous, and I think it's Union Bank that talks about they have to go outside the four corners of the contract and look at parole evidence, then the unjust enrichment claim should stand, and at least should stand until discovery has been completed. And again, here, this motion was
Counsel, in
filed.
light of 8D,
Yeah.
what's the ambiguity?
Well, 8D isn't.
It's a catch-all, right?
It's a catch-all. It's a reservation of rights. It's just the converse of Section 3. So it doesn't illuminate the nature of the rights or what is an episode or what is a season or what is a movie or an event or a special at all. It just says the opposite of what Section 3 says. And that is sort of implicit in every contract, I think, right? If you didn't have 8D and you had a contract that just said these rights are provided, implicitly the other rights aren't. That's all that 8D does. So I don't think it adds anything. I don't think it adds anything to the analysis, and I don't think it undermines the fact that the contract is ambiguous. Appellant here said something in their brief about the contract comprehensively covering every issue. It clearly does not do that. The Supreme Court already indicated that it understood that it would need to look at parole evidence and go outside of the contract.
Can a non-signatory be bound by a contract?
Not a non-signatory to a contract be bound to that contract? No, I wouldn't think so.
Can Paramount be bound to the Warner contract with South Park?
I wouldn't think so, Your Honor, no. And that's not our claim here. Our claim is that they're precisely that issue. They are not bound to the contract here. They are a third party who came in and received benefits at the expense of Warner Media, but not via the contract.
Can a non-signatory to a contract engage in tortious interference with another's contract?
Yes, Your Honor. If there are no more questions.
Thank you, Counsel.
Thank you, Your Honor.
I'll just briefly address Ms. Winston's point about ambiguity. So ambiguity is beside the point for the same reason that Section 8D sort of obviates the question about scope. So if Warner Media is correct that its interpretation of Section 3 means that it gets all of the South Park content that's at issue in this dispute, then it would win its contract claims, and that would be that, and the unjust enrichment claim would really
Your argument is, in this point, that the plaintiff is seeking content that falls within licensed content. And so therefore, per se, it's part of the contract, correct?
Correct. And to the extent that Warner Media is incorrect and South Park Digital Studios is correct in its interpretation of Section 3, then South Park Digital Studios would retain all of the rights to the content that wasn't licensed by Section 3. So these two provisions work in conjunction to basically ensure that there's really nothing that can fall outside the scope of this particular contract. And if the panel has no further questions, I'm happy to see the rest of the time.
Thank you, counsel. Thank you both.
Thank you.
Your briefs in both cases were excellent, although quite lengthy, but they were very good. Ramos versus Ford Foundation.
Good afternoon, Your Honors. May it please the Court, my name is Michael Kazores from the Law Office of Eric D. Feldman, and I represent the defendants, appellants Ford Foundation and Hennigan Construction. As Your Honors is aware, the main focus of my brief is the Court's sua sponte dismissal of my client's contractual indemnity claim against Harbor Mechanical. This was a claim for contractual indemnity that the Harbor Mechanical didn't even ask to be dismissed, and yet
the court has the power to search the record on a summary judgment.
Absolutely, it has the power to search the record and grant summary judgment, but it shouldn't have done that in this instance, because not only should the claim not have been dismissed under the facts and the law, but it should have been granted. Our contractual indemnity claim against Harbor should have been awarded to us on our motion as a matter of law. Under Brown versus Two Exchange Plaza Partners, it's quite clear that when Hennigan hired Harbor, Harbor subcontracted that work to Celtic, and Celtic's employee was injured on the job. As a matter of law, the plaintiff's accident arose out of Harbor's work. According to the
You're citing to section 6.2, correct?
Yes. The contract says that to the fullest extent permitted by law, Harbor will defend, indemnify, and hold harmless Ford and Hennigan for all claims arising out of Harbor's work. The accident of the plaintiff arose out of Harbor's work because plaintiff was employed by Harbor's subcontractor. Under the Brown case, that's undisputable. It's longstanding law in the state of New York. So given that, contractual indemnity was triggered, and the dismissal of the claim should be reversed in our favor and contractual indemnity granted. Now, once that happens, the only issue is it conditional contractual indemnity or unconditional contractual indemnity? It's our position that the plaintiff's common law negligence claims and the Section 200 claim under the labor law should be dismissed because my clients were not negligent.
Well, you claim that they weren't involved in the means and methods, and there was no conditional, no premises condition that would trigger it.
That's correct, Your Honor, and it's undisputed. And the plaintiff testified, quite frankly, that no one other than his own supervisor gave him instructions as to his work. Now, even if we talk about the person that was allegedly dismantling the scaffolding above him, that was still a Celtic employee.
Yeah, but the question is who gave him instructions? Isn't there someone from Harbor that gave him instructions?
There's some dispute.
And possibly someone from Hennigan who was the superintendent. I mean, there's a little bit of a mix.
Right. There was conflicting testimony in the sense that my client said that if we gave anyone such instructions, it would have been to Safeway, and that there was no reason for the scaffold to be dismantled at that time, whereas the plaintiff's coworker, Rowlow, told him that Mike from Harbor told him to dismantle the scaffold. So to that extent, there is a dispute. But you know, if there is no issue as to our negligence, then it would be unconditional. If there's a dispute as to our negligence, as Your Honor seems to be indicating that you might believe there is, then it would still be contractual indemnity, but a conditional order of contractual indemnity versus an unconditional order of contractual indemnity. You know, the final issue with regard to my brief is the labor law 240 claim.
Foot brace dropping.
Right. It's our position that under Narducci, this is an object that was not being hoisted or secured, but I understand that it's not our strongest argument.
Thank you for your candor, counsel.
Thank you. Thank you, Your Honor.
Who's up next?
I believe I am, Your Honor. Abe Reichek from Katz and Reichek, representing Harbor Mechanical Corporation. May it please the court. There's no dispute. All the evidence, plaintiff's testimony, testimony of Celtic, testimony of Harbor, all indicate that this accident resulted from Rallo being usurped out of the contract of Harbor, out of the contract of Celtic, to go ahead and dismantle a scaffold. He wasn't permitted to do so. He wasn't qualified to do so. He wasn't licensed to do so. This takes it out of the contract. This was Safeway's contract to be involved in scaffolding.
Got some very broad indemnification language in your contract, though, counsel.
There is broad.
All claims, including claims that arise from the work of subcontractors. So how do you deal with that?
Because this did not arise out of or was not connected or related to Harbor's work or Harbor's subcontractees' work. In the way they wish this provision to be applied would violate the GOL. They're talking about their negligence. Mike Lyons.
No, but the saving clause is in there too. You know, the savings clause that, to the extent permitted by law. So doesn't that obviate that argument?
Not the way they're using it under these factual circumstances.
How so?
It's our position that because this had nothing to do with the contract, with Harbor's contract or Celtic's contract, this is where someone was taken to do something different and outside the scope. All the cases appellant cites to, in terms of a finding of contractual indemnity, all relate to circumstances where plaintiff is engaging in a course of conduct in that contract, that subcontract that goes towards the general contractor. In this case, that's not what's going on here. He is not engaging in that. He's standing there doing duct work, and this thing falls from stories above because someone is doing something that Safeway was supposed to do.
Are you saying that the ductwork had nothing to do with the HVAC?
The ductwork had nothing to do with the dismantling of the scaffold and the foot brace that, as a result of that negligent dismantling of the scaffold, fell from above. Plaintiff is going...
So in other words, the HVAC, I mean, the piping did have to do with HVAC, right?
I'm sorry, which had to do
The
with the HVAC?
ductwork had to do with the HVAC.
The ductwork had to do with the HVAC.
Yeah,
That's not what happened here. What happened here was a foot brace that fell from the scaffold.
Right.
And the foot brace from the scaffold was because the gentleman should have had no business dismantling that scaffold. That's not within the scope of that contract. The general contractor itself is engaging in that work through Mike Lyons.
Okay. Any questions?
Thank you.
Thank you, counsel.
Good afternoon. Brendan O'Mara for the plaintiff respondent in relation to the latter issues in regards to the initial brief, the 240 and the 200 claims. I do not have a substantial amount to add to the brief that was submitted, other than I believe it's a relatively straightforward 240 case in regards to an elevated mechanism causing the injury, and I believe there's a substantial amount of facts that are in contention in regards to who controlled the method and means of the operation and whether or not it was a dangerous condition, particularly in light of the fact that they had individuals working in that shaft without having any sort of netting to prevent this type of injury from occurring.
And your expert was unrebutted, right?
There was no rebuttal to the expert, Your Honor.
Thank you, counsel.
Thank you for your time.
May it please the court, Ralph Cosentino for the respondent, Celtic Sheet Metal. My client was named as a respondent, but there's nothing in the appellate brief that was adverse to my client. We're just here to make sure that there was nothing adversely said or done today to disturb the decision as to Celtic. Any questions, I'm happy to answer.
Your brief was admirably short for that reason. Thank you, counsel.
Your Honors, there's absolutely no case law cited by Harbor that supports their position that because the dismantling of the scaffold was unrelated to Celtic's work, that this somehow takes it out of the contract. The fact is that the plaintiff was doing the work that was contracted to Harbor and then subcontracted to Celtic, his employer, when he was injured. That's all that matters. He was on the site doing the work that his employer was hired to do. When he was injured, that injury arose out of the contract. Nothing else matters. As I said earlier, contractual indemnity is triggered. The only issue is whether it's conditional or unconditional. Thank you.
Thank you, counsel. Thank you all. Costanzo versus American Academy of Dramatic Arts.
Good afternoon, Your Honors. May it please the court, my name is Louis Grandelli from Grandelli and Eskenazi for the plaintiff. As the court knows, this is an incident where the plaintiff fell down a flight of stairs at a building at 120 Madison Avenue, which is owned and maintained by the defendants for many years. This building had a long-standing damp and humid condition in the basement, which, because of complaints by their own employees, necessitated first plastering by just in-house maintenance personnel.
Yeah, I mean, you make that point at great length in your brief about the humidity in the space. But what is there in your presentation to the Supreme Court that shows that the fact that there was corroded metal on the stairs would give rise to actual notice that the wooden step would crack the way it did?
All right, so our expert connects the dots, and he based on the evidence from the admissions of the defendants themselves, this was a long-standing humid condition that caused corrosion over many years. And he explains that, first of all, he explains why the incident happened 20 years ago, where there were cracks to the steps and the plywood had to be repaired because of this humid condition. The defendants have never rebutted that. If you
Yeah, but the steps that were there before, unless I'm mistaken, were plaster steps, is that right? Or it was not a wooden surface?
No, they were concrete steps that were replaced because of complaints that their prior repairs were not done properly, so they just put plywood overwoods. And if you look at the pictures, they use these little, like, retrofitted angles, which don't even rise to the level of the risers themselves, and they're not secured at all. If you look at the pictures of the steps, the stair frame, which supports the treads, you could see holes in them in the pictures, and I have the picture numbers. But to answer your question, Judge Smolden, our expert says that because of this deterioration of the stair frame, it causes subsidence and demurration and corrosion, which caused additional stress on the stair treads. And that caused unnecessary stress on those stair treads. And that's why, even before this, there were cracks to those steps, which were never addressed by a professional engineer, anyone with any competence in stairwell maintenance or construction. And the fact that there were complaints and this long-standing condition and the need for prior repairs, the fact that they never got a permit, they never got a contract, they never got an architect or an engineer.
So you need a permit to repair steps?
Well, our expert says you did, and if you read their expert affidavit, Shabansky's affidavit, he doesn't even mention the name Fuchs at all. Our expert Fuchs says because of the subsidence and the deterioration of the stairwell, it caused this additional stress on the wooden tread. He explains why this long-standing condition caused the deterioration and the vulnerability of these steps, and nowhere in Shabansky's affidavit did he even mention the name Fuchs. He doesn't consider the expert affidavit. He doesn't address it in any fashion whatsoever.
Counsel, does this case boil down to a battle of the experts?
Not, absolutely not, for the reason I just said, Your Honor, because
I mean,
their
you argued res ipsa, which was very interesting, but the lack of inspections was very interesting, because obviously going up and down steps every day does not amount to an inspection. But
And this court has found that. This court has found that. Just that's not adequate, especially under these circumstances. But Judge Moulton, you had a case, Judge Moulton, earlier this year, Fuentes, from February of 2025, which wasn't cited in our brief, and it involved a woman who was walking on a sidewalk which collapsed. And this court repeated its earlier principle from a case Conklin from 2018 from this court. A sidewalk and a step does not ordinarily collapse in the absence of a
Fuentes, they raised that on their initial motion papers, unless I'm mistaken, and you didn't raise res ipsa until your reply. So maybe we can consider it in opposition to their motion, but can we consider it on your direct motion?
Well, res ipsa is something that doesn't even have to be pled in a complaint or a bill.
No, that's true, but it needs to be raised in a motion initially, I believe.
It was raised in our opposition to their motion. And it was addressed in their reply to our underlying motion, and it was addressed in our initial brief to this court. And we cite all cases from this court. And yours is not cited, but when I say yours, the case that you were on.
I don't think did you raise, maybe I missed it. I thought you did not raise res ipsa until your reply.
But it was also in opposition to their motion. So
Right.
It was in opposition to their cross motion for a summary judgment. That's where it was raised, and it was addressed by them. They got a chance to rebut the res ipsa argument, but they didn't. And this case is materially indistinguishable from this court's decision in Fuentes from earlier this year, where a woman fell on a sidewalk which collapsed, and this court said notice is not even an element, and you granted summary judgment for the plaintiff as a matter of law. In this case, not only do we have res ipsa that applies, all three elements apply. We also have a created condition because they knew about the dampness that was caused by their boiler and seepage from the water, actual notice because there were complaints by their own employees, and constructive notice because this went on for 40 years. And you could see from the pictures and just their own testimony how corroded this steel frame that supported the steps were.
Thanks, counsel. You got time in rebuttal.
Thank you, Your Honor.
May it please the court, good afternoon, Your Honors. Kahana Feld by Michael Curtis for the defendant, respondent, cross appellant, the American Academy of Dramatic Arts.
Counsel, if I may, going back to the plaintiff's case, there were no complaints or prior complaints or prior accidents regarding the wood tread, right?
None whatsoever, and not just the wood tread, the stairs themselves. The only person who said they ever lodged any sort of complaint was the plaintiff. That was disputed by the defendants, and plaintiff did not say that he had any complaint about the wood tread or about the stability of the staircase. His complaint was, there's some rust, the water down here is bad. Plaintiff was an exterminator, and the water contributes to these water bugs and the vermin in the basement. So that was the substance of the complaint.
I just have one more question, and I'll let you continue. Now, did the plaintiff present any evidence that this alleged defect regarding the wood tread, that it was, apparent or visible in any way before the accident?
No. And I would dispute counsel's characterization that Fuchs connected the dots, Fuchs being the engineer for plaintiff. We set forth, just because I probably won't reach all of the deficiencies in his opinions, in our brief, we really aggressively attacked his report. It's very speculative, very conclusory. And our criticisms were not addressed by plaintiff in their opposition to our brief. And I'll direct Your Honor's attention to page 15 of our reply brief, where we made a list. These are all the criticisms and deficiencies that plaintiff ignored and did not address because he could not address them. There is no connection between the wooden tread and the rusty condition of the staircase.
Would you agree that on this record, not only was there no actual notice, but there really was no constructive notice of this particular latent tread?
Yes, there was no constructive notice.
And the various other inspections that may have occurred in the basement had absolutely nothing to do with the stairs. They dealt with the boiler and other issues.
Well, the fire department did annual inspections looking for code violations. So they were formally inspected at least annually and as many times as three or four times a year by the fire department.
But there were no violations.
No violations and subject to more regular use of the staircase.
But you'd be talking about fire code violations, right? Fire department would not be issuing building code violations.
That's correct. So,
and I know that you mentioned the fire department, I believe the boiler company as well, but neither entity ever inspected these stairs, right?
Well, I don't know that the record says they inspected them specifically. To the extent that they would have inspected them to look for code violations, they would have. They certainly used them not only during their annual inspections, but the day before plaintiff's accident, along with two other vendors, plumbers. They were all there for the same issue to address a standing pipe issue, and they all used the stairs and they, with no issue, along with two members of the defense staff. There was never any issue whatsoever with this stuff, and that parlays into the res ipsa loquitur argument. It's, they raised the issue. It's their burden to show that we had exclusive control of the staircase, and to discharge that burden, they had to show that these non-defendant, non-parties probably did nothing to cause.
I don't know about that, counsel. I didn't think that was your strongest argument in your brief. The stairs are in your exclusive control because they're in your building.
Right, but the defense has to, the plaintiff has to demonstrate their burden to show that these non-parties probably did nothing to cause the issue with the wooden tread.
I don't think we'd ever have a res ipsa case. There would never be a res ipsa
Well,
case.
just for the sake of argument, let's say all these elements are met. Of course, just meeting the elements of res ipsa loquitur does not entitle you to summary judgment under the doctrine. Meeting those elements entitles you only to a permissible inference at trial. And the Court of Appeals has held that it is only in the rarest of res ipsa loquitur cases that a plaintiff can be granted summary judgment under that theory of liability.
So you're agreeing that there's issues of fact? You are agreeing that there are triable issues of fact? You are agreeing, in fact, with the court?
I don't. I maintain that plaintiff failed to demonstrate that the defense had exclusive control of the staircase, but if your honors disagree with me, then I would say that plaintiff certainly failed to meet that high threshold set by the Court of Appeals, which requires that the plaintiff's circumstantial evidence be so compelling that there could be no doubt.
How did your client establish that, your inspections could not have disclosed the defect in the wooden tread? How did your client establish that?
Well, we have this. What is a reasonable inspection of a staircase? And I would point your honor's attention to the case of San Andres v. 1254 Sherman Ave, as cited in our opening brief, which holds that a defendant may satisfy its prima facie burden with evidence of regular walkthroughs that would suffice to arouse suspicion if a condition did exist.
Is that enough under the circumstances here, where there, if my memory serves me, there was about an inch of water that was permanently there. There's this high humidity. One would think that having standing water and high humidity for years upon years will have an adverse effect on wood.
Well, the wood didn't rot; the wood split. So, there's evidence to record there's no water damage or humidity damage to the wooden tread itself. There's some cosmetic damage, some rust on the side of the staircase, which does not affect the structural stability of the staircase itself.
Says who?
Pardon?
Says who?
Says who? It's not on us. We met our prima facie burden. Plaintiff's expert is the one who says that happened. His opinions and evidence have to be credible and founded in the record to raise the issue of fact necessary.
Or alternatively, there's a battle of the experts.
I don't know that we need our expert to meet our burden, but plaintiff expert failed to raise an issue of fact on our summary judgment motion.
Thank you, counsel. You have time, rebuttal.
Thank you.
May I, Your Honor?
Please.
In response to your question about prior accidents, Your Honor, there were prior complaints by people that worked there about these cracks being dangerous, and that's why they tried to fix these steps, but they did it in-house to save money rather than hire a professional contractor.
Counsel, aren't you talking about apples and oranges? They were concrete steps which were repaired with plaster, which is very interesting, and then the remedy. The subsequent remedy was to put wooden treads on them.
So they were initially, correct, try to be fixed with plastic, but the people still complained. The people that were using the steps were still complaining. So then they put some concrete on top, then they put the plywood on top of it. But again, our experts said this is an accident that was waiting to happen because the underlying condition was never remedied. And we don't have to—
You're correct. There were prior complaints, particularly the plaintiff indicated that the complaints were made about the sub-basement having water, rust, mold, and also the plaintiff denied any prior accidents on the stairs, but certainly there were complaints, but not regarding the wooden tread.
But the steel frame was completely deteriorated, and that's what caused the underlying condition. That's what caused the steps to crack from 20 years before this. Our expert explains that. Their expert never addresses why the issue is in this 8-story building with all these steps, hundreds of steps. These were the only steps were a problem for all those years. They knew about this, and they never addressed it. And our expert explains how this is foreseeable. If you look at these pictures, there's holes in these metal frames. If you look at picture, and that's 688 when you review the record. If you look at 702 in the record, you can see how it's all deteriorated in the frame. And look at these angles they try to use. They don't even rise to the level of a tread. These are makeshift repairs. These are not professionally done. They didn't adequately secure the tread, and because they didn't adequately secure the tread, it was vulnerable, it had unnecessary stress, and that's what caused this accident. This was an accident waiting to happen that was completely foreseeable.
Thank you, counsel.
Nothing else? Thank you, Your Honor.
Thank you.
Very briefly, first, there's nothing in the record that explains why these concrete steps, 10 to 15 years before plaintiff's accident, suffered some cracking. Not all of the steps, not pervasive cracking. Some steps had some cracks. Nothing in the record explains why. They repaired those steps only, leaving the other concrete steps, which for the next 10 or 15 years didn't crack. So Fuchs just concluded, well, it must have been the humid condition, because that's helpful to plaintiff's case. There's no evidence, there's no discussion or explanation of how that is so.
But you yourself talked about the significant foot traffic the day before the accident, right?
Right.
Going up and down these steps in a building that's landmarked, built in 1905, that has a sub-basement with an inch's worth of water in the boiler room, and which has extermination needs so important that the plaintiff had to come every 2 weeks. So under the circumstances presented with an old building, for me, the lack of an inspection of the steps raises questions. I'm not saying that it's dispositive, but it raises questions as to whether the steps were in proper working condition.
Sure. Well, the steps were not built when the building was initially constructed. The steps were built about 40 years before plaintiff's accident.
Mm-hmm.
I take Your Honor's comment. But just with respect to the lack of inspection, I want to talk about Fuchs's inspection. Counsel talked about the images and the pictures of corrosion and the attachment and the connectors to the wooden tread. Fuchs never identified the specific step that cracked. He never particularized his inspection of the staircase. He never talked about these are the connectors and the hinges relating to this step. He took a picture of one step very up close, didn't say which one it was, and it couldn't have been the step in question because there's no crack in it. After the step cracked, they repaired it by putting another wooden piece of plywood or wooden board directly on top of it. They never removed the cracked wood, and Fuchs never inspected it. It was right there for him, and he didn't. So, if Your Honor has any questions.
Thank you very much, counsel. Thank you both. Vasquez versus New York State Office of Children and Family Services.
Good afternoon, Robert Schechter for the appellant. This is a rare case that starts all the way in an administrative decision. We get an Article 78 and we get transferred all the way up to the appellate division. We have a chance to finally have a true independent oversight on what is actually happening when ACS gets involved in people's lives. We get to see what happens, which was a complaint about tardiness was made against child E. ACS looks into all these people. We ended up finding against H for having absences that were 19. We find that E's 82 and A's 56 absences are not neglect, but we're gonna substantiate H's 19, and that'll be the only child that we...
Counsel,
please.
I'm sorry. I'm not sure we're on the right case. This involves a disabled child, immigration. Is that this case?
No.
You're talking about
This is an educational neglect case.
This is
So one
number
involving
11.
absences. Yeah.
Absences in school.
But the absences were extensive. The 37 days during the first term of the 2017-2018 school year, and only 18 notes for of those 37 days. I mean, that's very similar to our other precedent saying that that is educational neglect.
Well, when we look at which ones were unsubstantiated or which ones were unexcused, they come with 19. Now, this is again a child with epilepsy, asthma, ADHD, all these other things. So these medical conditions will continue to happen. And just because you don't have a doctor's note doesn't necessarily mean that that's neglect because your child isn't there. He's still suffering from these same
But it's by
instances.
providing the medical documentation that you establish that it's not neglect, right?
It would certainly be helpful had the pro se individual had those doctor's notes and
she
provided
refused.
it.
She did not grant permission. She didn't waive HIPAA, correct?
But that is, again, when ACS is investigating somebody, they show up and give them a blank HIPAA authorization and say, let us continue investigating into you and we'll see what happens. And they even indicate afterwards that she did provide the HIPAA authorizations to ACS. But again, in this case, the one child that they substantiated was less than the unexplained absences of the other two children.
That
This
helps.
seems very...
Does that really help your argument? Does that really help your argument? We're talking about the education of a child who doesn't even have a teacher coming to the home.
This particular child was never even held back and is currently going to graduate this year. Has absolutely never suffered any educational neglect, is going to graduate with a Regents diploma this year. So
Is that in the record, counsel?
no.
Well,
Then
counsel,
don't bring it up.
I like to bring up another issue because here the child did exhibit, various developmental delays and did not constantly receive the IEP services that were meant to address those delays due to the extensive absences. And the record indicated that the child's promotion was in doubt. So
The child was promoted, and that is in the record. Because it was, but they needed a promotion in doubt letter, I believe is what they needed was, and that never happened because again, the child was promoted. Had the child been held back, then I could definitely see the argument that they were being neglected.
So that's the litmus test. Was the child promoted or not?
I think that if your child was promoted, that you're not neglecting the child. I also think
Even
that
if there were 37 absences and 27 latenesses in one term.
Now, when we go, I think that it would be important to look at each individual lateness and look and see where it is to see if the child was on a bus or not. Again, hindsight, had this individual who was pro se been represented by an attorney, which they do not get, while they're going through this, they could present a much better case. But they are often poor, marginalized members of society that are fighting for their families in a situation completely unknown to them.
Who's fighting for the child to get a proper education?
The mother is fighting to make sure her child is able to go to school once this child is graduated.
Justice Moulton, may I just pose one question, only because you brought up the busing, and can you address the mother repeatedly dropping the child off? I believe it was like a half an hour to an hour late in the morning, and then picking him up almost an hour before school ended in the afternoon, although the child qualified for door-to-door busing. Can you address that?
So that, again, I believe there was a disagreement in the record as to whether the child was being dropped off late or not. I believe she had argued that when she goes to pick the child up 30 minutes or so before that was the time that the school had told her to. Ultimately, I think this was a situation where the school and the mother ultimately were having some type of disagreement. Neither here nor there. Ultimately, these children were moved out of the school, and there's been no issues. But I do think that the fact that ACS, or Office of Children and Family Services, ultimately did not try to remove these children from this family's home seems to really suggest that they didn't really think anything was going on.
Thank you, counsel. You have time, rebuttal.
Yep.
Good afternoon. I'm David Lawrence III. I'm an Assistant Solicitor General appearing on behalf of Respondent, New York State Office of Children and Family Services. Substantial evidence supports the determination that petitioner maltreated her son by committing educational neglect. In particular, the child during the first term of the 2017-2018 school year was absent 37 times. The school was provided with physician's
Counsel
notes.
says that there was medical reason for that and that the mother signed the HIPAA. So how do you respond to that?
In the first place, the mother did not provide physician's notes for 19 of the 37 absence days. Subsequently, during the ACS investigation, the mother declined to sign a HIPAA form or to disclose the names of the child's medical providers so that the ACS investigator could investigate these matters and confirm the mother's allegation that the absences were for medical reasons. She only signed a HIPAA form after the investigation had already been completed. As far as academic harm to the child, this was established by, among other things, the statements in the caseworker's records that the school guidance counselor had said that the child was in danger of not being promoted to the next grade, that the absences were harming the child's academic performance. You also have the child's IEP itself, which is in the record, which shows the child was performing inadequately for its grade level in reading and writing and mathematics.
Now, counsel, the IEP, I believe at the hearing, the mother denied the existence of an IEP, but the records from I think it was the 2017-2018 school year demonstrated that that was not the case, that there was an IEP.
Yes, Your Honor. As far as the point my adversary makes about certain children were found to not have been maltreated and this child was found to have been maltreated, those two other children had different circumstances. One of the children had received a Department of Education hearing officer's decision finding that the child had not been provided with an adequate school placement by the school system, and as the other child, the OCFS hearing officer found the child's academic performance was not harmed and that he was meeting his academic goals.
Counsel, did the mother ever provide any medical evidence to explain the child's medical conditions or their impact on his ability to regularly attend school?
The only medical documentation that the mother provided that appears in the record all relates to all dates from dates from January 31st, 2018, which is after all these absences had already been incurred, and forward. So there was no contemporaneous medical documentation provided at the OCFS hearing as to the time period at issue here. The school said that the mother had provided absence notes for some of those absences during this time period from physicians, but, and we don't doubt that there were notes provided for those 18 days, but that leaves 19 unexcused absence days for which there was no medical justification established. I ask the court confirm the determination, deny the petition, and dismiss the proceeding. Thank you.
Thank you, counsel.
Tahir Sadria, appearing on behalf of the Administration for Children's Services.
Counsel, you think that ACS should not be a proper party respondent, first argument, right?
Yes, that is
Why is
correct.
that?
Because the Administration for Children's Services does not have the power to actually grant the relief that the petitioner is seeking. It is solely the determination of the office, the OCFS. They are the ones who decide whether or not
Whether there was
there
maltreatment.
should be an unfounding of the indicated report. And so that initial determination based on the record and then the determination based on the on a hearing, it is entirely the OCFS determination, and that is what this court found in Woodley v. Poole. Alternatively, the ACS does believe that the determination should be confirmed for all of the reasons that my colleague from OCFS has stated. There was excessive absences. There was evidence in the record of actual harm to the child. And the hearing officer reasonably found that the mother had not, did not credibly show that that all of these absences were due to medical necessity. If the court has no further questions, I will rest on my brief.
Thank you, Counsel.
Just briefly, it does appear again that the law has since changed to not allow a situation like this where when the Article 10 petitions are dismissed, that you don't end up with a situation where you can even have a administrative law judge issue these types of decisions because it was not fair or right.
But do you establish that that applies retroactively, though? Because I didn't think you really did in your brief.
Well, I don't think it even could apply retroactively, but I think it is something that is important to consider. And the reason it probably doesn't apply retroactively is because you'd have to go back to all those people who had on their records saying that they were indicated. You would now have to then say those are unfounded and removed, but the damage has already been done. And that's probably my guess why the legislature did not specifically state that it applied retroactively. But the legislature did look at it and saw that this was not an appropriate result and did what they can going forward. And the fact that we now have a chance to look and see, could a reasonable mind come to this conclusion? I don't see how anybody could come to this conclusion. Again, this is a mother who's just doing the best that they can with their children, getting them to school. The kid is sick. They're not always going to have a note. They also don't even have an attorney to tell them what they need at these hearings that are months and months apart. They're taken off.
Counsel, due to the excessive absences and lateness, was there any evidence that the mother was working with the school authorities to try to implement some type of homeschooling or an alternate arrangement in light of the
I believe that she had indicated at some point that she tried to work with them, and I think the school told them that not to do that. Ultimately, I was not there. I do believe she said that she was trying to work with it. I do know that at the end of the day, that the kid is suffering from asthma. They're saying there's rats. They're saying he's not doing well when he's sick, and he's going to school. He's graduating. I just don't, it doesn't make sense to me when I looked at it when she came to us, and I don't think there's a lot of these cases that get up here, because it takes a lot to hire a firm to go and file your case years ago in the Bronx. We ultimately get a decision to get transferred up here. I mean, this is from 2016. 2017 is when this is from. And a lot has changed since then, but I certainly don't think that you can find that only one of these kids was educationally neglected, not the other two. This is one of those situations where it looks like the judge just went, someone has to be happy. ACS has to be justified.
Counsel, you did make that point in your brief. Do you have any other questions?
Oh, no.
Okay, thank you, Counsel. Thank you all.
Everybody.
People v. McNeil.
Good afternoon. May it please the court. Legal Aid Society by Everett Hopkins for appellant Mr. McNeil. Your Honors, this court should set aside the verdict of robbery because it was against the weight of the evidence. It should also, this court should also reverse the remaining convictions because the jury commingled the evidence between all of the offenses, and the court did not instruct the jury to do otherwise.
The defense counsel at trial did not request the commingling instruction, correct?
He did not specifically object it, however, but what I would say, Your Honor, is that this court can reach this issue in the interest of justice, but also it should be noted that in the defendant's severance motion, the court did acknowledge a need for a potential instruction to limit the jury's ability to commingle the evidence.
But also, in this case, would commingling instruction have been appropriate because the modus operandi of your client and the person who was with him at the time would be relevant, wouldn't it, in terms of evaluating each of the offenses?
Well, I think it wasn't modus operandi here. I think that's the issue, right? Of course, there is some similarities between the offenses, but the prosecution didn't rely on modus operandi. And I don't think defense counsel really made that the spotlight of his defense. But it's worth noting that there are similarities in the instances. 2 of them occurred on the same date. 2 of them occurred at the same location. All of them
Some of the merch from Diesel fell out during the course of the second incident at the sunglasses hut, right? The jeans fell out of one of
There were a pair of jeans that fell out. However, it's you know, I would say that it's not clear that that's from the Diesel store or that it's in any way connected to the incident.
Whether it's clear or not, that's an argument that the people are free to make, right? So that the jury could make a determination.
Sure, that's the argument they can make. However, there has to be something that connects the 2 instances together that would make it so that a no commingling charge would be, you wouldn't need one. Here, we don't really have that. What we do have, though, is a similarity in the offenses where the jury is now able to infer guilt based on stronger evidence in one of the instances, which is, for example, the robbery, which has the most evidence. Now, if we look at the robbery, there's video, there's witness identification, there's more interaction between the so-called accomplice and Mr. McNeil. But then if we look at the petty larceny, which I know is a misdemeanor, but it's worth noting here, there's no video. There's really no interaction between Mr. McNeil and this other man, right? What are the facts in that case? Mr. McNeil walks into the store, goes to a different section of the store, picks up a fragrance bottle, drops it, and leaves. Meanwhile, the other person who he's alleged to be acting in concert with is walking throughout the store, trying on clothes, then taking the jeans and leaving the store. Where is the aid in that case? There's nothing showing that Mr. McNeil aided this other man in committing a crime and taking these jeans. So I would submit...
The prosecution, well, he was convicted of petty larceny. That's not a requirement of petty larceny, right?
Well, it was on the acting in concert theory because Mr. McNeil didn't leave that store with anything in his possession. He didn't commit any petty larceny in that day. So the theory was that he aided this man commit a petty larceny when he took the jeans. So where is the aid in that case? There's nothing there, right? So I would submit that if petty larceny was the only charge being tried right then and there, the jury would have to acquit because there's nothing else showing. The only way they convicted on that charge was that they looked at the robbery incidents, they looked at the grand larceny incidents, which has more evidence, and was able to infer that because of what he did in those 2 cases, he must have also did it here in petty larceny, and that's what really deprived him of a fair trial. With regards to the robbery charge, Your Honor, it's against the weight of the evidence because at a certain point, Mr. McNeil no longer shared the common intent to use force to commit the larceny. And we know that because, as this court has said, shared intent when it comes to robbery is the linchpin when you're going on acting in concert theory. So there's no shared intent because Mr. McNeil gave the property back to the store employee. He then asked the other man to give back any sunglasses that he had.
Couldn't the jury derive an inference that since Ms. Torres said, I didn't get all the sunglasses back, that there were still some sunglasses on their person, or they took them from the store?
Well, I think the record supports more so that there's no records on Mr. McNeil's person. Now, there may have been some on the other man, but there's nothing else on his person. I submit that he gave back all the property.
What about the video, which, let me turn on my mic better. What about the video that I watched? Torres is blocking the door.
Right.
I know you have 2 gentlemen wearing fedoras. I believe the defendant probably was the one in the black jacket wearing the white fedora. And both, there's a tussle. The gentleman in the white fedora that I believe is is a defendant, certainly had contact with her, pushed her, followed by the other gentleman. So there was a tussle. Ms. Torres fell to the ground. They exit, they come back in and grab something. So it looks like there is some force coupled with Ms. Torres making that 911 call and elaborating, you know, how force was used. She wanted them to stay in the store, and they were pushing against that to exit.
Right, and I think it's the intent that matters, right? Yes, there is some force, but as this court has stated, as the other courts have stated in my brief, it can't be unintended force. It can't be incidental force. There has to be a mens rea that he intends to use force in furtherance of the larceny. So our position is that once he had gave up the property, once he had encouraged the other man to give back all the property, and once he had asked to leave, his tussle with Torres was to leave the store. It wasn't in furtherance of any type of larceny.
Well, with the property, as my colleague said, because there was still property that was missing, you know, when Torres went to look and then advised the 911 caller that there was still property that was missing from the store.
There was property missing, and we'll concede that. But again, Mr. McNeil had gave back all the property in his possession, and when he was arrested about 1 to 2 minutes later, there was no property found on him that was stolen.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon. May it please the court, Jennifer Westfall for the people. I'd like to first start with the acting in concert at the Diesel store. The testimony very clearly says that the two came in together, were conversing together before they split up in the store. The accomplice was only able to exit the store because when he raised his voice, defendant came back in and started speaking loudly, saying, "We don't owe them anything. They need to apologize to us. Come on, let's go."
You're talking about the May 17th incident now, right?
No, this is the June 23rd Diesel.
All right.
There was no video there, but both employees testified that the two came in together and interacted in this manner. They said it was clear to them that they were together in this endeavor.
Being together is not enough. How did the defendant aid the other person?
So he left when he dropped the fragrance bottle, and he was standing outside the door. When
I'm sorry, when you say he, please identify.
I'm sorry. When defendant dropped the bottle, the fragrance bottle, and stood outside the door, he said he had to leave. His accomplice was still trying on jeans in the store. When Cruz attempted to stop him and say, "Come on, man, just give me back the jeans," the accomplice started raising his voice, started pulling down his pants to show he didn't have anything. It was making a scene. And that's when defendant came back in and said, "We don't owe them anything. Let's just go. They need to apologize to us." So that interruption pushed the employees to not continue to interact with them, and they left together. So that assistance helped the accomplice get away with the pairs of jeans. With respect to the jury's verdict on the robbery charge comported with the weight of the evidence, I think the video speaks for itself, and I would ask that you watch the video when it comes to
Well, how do you respond to your adversary's position that once he gave back the property and was just asking to leave, that the intent changed?
because defendant put 2 pairs of glasses into his jacket, and you can see each instance on the video, and he only gave back 1.
So you're relying on he must have had the other pair because it was not recovered.
So he must have still had the pair, but also Torres testified that his accomplice had a pair of glasses in his hand and never gave them back. Defendant asked to give them back, but never saw that interaction happen. He knew his accomplice still had the glasses. So one, we maintain that defendant still had a pair. It's irrelevant that he didn't have them when he was found a couple of minutes later, because who knows, maybe they got crushed in the tuffle with Torres and he tossed them. There's any number of reasons why he didn't have them. But 1, he still had a pair, and 2, he helped his accomplice get out, and he knew that his accomplice still had glasses.
Counsel, I just want to go back now with the first Sunglass Hut incident and then the Diesel. The 2 persons came in together, entered the store together, right?
Yes.
And then with the robbery 2 charge, 1 person entered the store, I think it was, I'm not sure which one, but the second person entered about maybe 30 seconds later, right? And pretty much had the same clothing as the other incidents on other dates.
Yes.
Wore the same things.
Yes. And they, again, the video shows that they were interacting with each other during the robbery. So they stood together by the wall, they conversed by the door, and they used force against Torres together. One was pulling, one was pulling on Torres, one was pulling on the door, and they went back and forth in exchange of that. If there are no further questions, we just ask that you affirm.
Thank you, Counsel.
Just briefly, I think it's worth pointing out that just the mere presence of being with someone who's committing a crime is not necessarily acting in concert.
That's not enough. Counsel, are you challenging the Appellate larceny conviction?
I'm sorry?
Are you challenging the Appellate larceny conviction?
Yes, all of them, we are, because of the non-commingling
So it's on the jury instruction, but not in terms of whether the prosecution established the elements of Appellate larceny.
Well, yeah, we are challenging that because it's based on the acting in concert theory, right? And so because...
Well, that's what I understood in the oral argument. I just didn't get that from the paper.
Okay, yes, that's correct, yeah. We're challenging that conviction as well, Judge. But I think it's still just worth noting as well, just on my last point, that even if the two individuals, Mr. McNeil and the other man, had a larcenous intent, once the other man doesn't give back the glasses he has and uses force, there's now a difference in a change in intent. And so there has to be more evidence presented by the prosecution that shows that Mr. McNeil intended to participate intentionally or intentionally aid the other man in using force for his larcenous
Does
intent.
that change if the defendant still had it, assuming that the jury could find, not assuming that, apparently they did find, that the defendant still had a pair of glasses in his possession, despite his asking the other person to give back the glasses and to let him go, he still had a pair and left with the pair. If that was found, is there any issue with the verdict?
Possibly, Judge, there could be, but I would submit that the jury there's nothing showing that the jury believed that, right? So that's the whole point of the commingling charge, and that's why we're asking that this be reversed for the weight of the evidence. Any other questions?
Thank you, Counsel. Thank you both. E-Trade Bank.
Good afternoon, Your Honors. May it please the Court. Anthony R. Filosa on behalf of Defendant Appellant. The judgment of foreclosure and the order of the Supreme Court should be reversed because, respectively, the Supreme Court conflated the nature of the relief that appellant sought under CPLR 5015A4. Appellant moved to vacate the default judgment of foreclosure and sale under 5015A4 for lack of jurisdiction because notice of motion of the default judgment of foreclosure was not served upon appellant. He was entitled to that notice as an appearing party, and hence under 5015A4 was the proper vehicle because it's axiomatic that the failure to give a party proper notice of a motion deprives the court of jurisdiction to even entertain that motion. It renders the resulting order a nullity, and it is a complete and absolute excuse for not opposing that motion. And that's embodied in this court's precedent, Bacon v. Nygaard, 232-83D-407. It's a 2024 case that emanated from this court. As an appearing party, Mr. Plodge was entitled to notice. The only argument that the respondent makes, they concede they didn't serve the notice of motion upon Mr. Plodge. At that time, Mr. Plodge was self-represented. He had filed a consent to change attorney.
I missed your firm. What's the name of your firm?
Rosenberg, Fortune, and Laitman, on behalf of defendant appellant Adam Plodge.
Okay.
So at the time of the filing of the notice of motion for a judgment of foreclosure, Mr. Plodge was self-represented. He had been self-represented for over 90 days. And here the chronology is important.
Yeah, he wrote his own brief in this case, right? Or at least the initial brief is by Mr. Plodge.
Yes, was by Mr. Plodge, correct.
Okay, thank you.
Yes, so the chronology is important because we have in June of 2015, Appendix 201 to 206, there's a consent to change attorney form where Mr. Plodge elected to act pro se. The form is signed by outgoing counsel. It's acknowledged by Mr. Plodge. It's filed with the clerk of the court. In August of 2015, that's Appendix 206.
Does it matter that Mr. Plodge didn't put any contact information on that, or am I mistaken about that? We didn't know how to, or the court system or person reading that would not know how to reach Mr. Plodge. Is that fair to say?
No, in the sense that, one, I think they were on notice of, they served Mr. Plodge.
They served Mr. Plotch with service of process, so they certainly knew how to contact Mr. Plotch. And more to the point, Your Honor, also, we have in August of 2015, when the bank continues to serve the substituted attorney, Attorney Crawford writes the bank and says, I no longer represent Mr. Plotch. That's Appendix 206. Again, in September of 2015, when the bank yet again serves the very motion that's the subject of this appeal, he rejects service. Attorney Crawford says, you can't serve me with notice of motion of the JFS. I no longer represent Mr. Plotch. Here again is a copy of the consent to change attorney. That's Appendix 376. The bank acknowledges receiving that correspondence from Mr. Crawford. That's Appendix 261.
Was the substitution, was that was filed in NICEF, right?
Correct. That was filed with, this is a paper case. It was filed with the
clerk of the court. It was filed in the clerk of the court. Okay.
Correct. So again, and they don't quarrel with that. They make a misguided legal argument that says, well, because there was no order relieving Attorney Crawford, he was still counsel of record. But 321 is phrased in the alternative. You either need a consent signed by the outgoing attorney and acknowledged by the client, and that's what we had here, or a court order. That's apparent from the use of the disjunctive. That's apparent from the cases that we cited in our reply brief, page 8, where it's, the court, this court has explained there are alternative ways, one of which being a consent, the other being a motion on notice with a court order, which would relieve a party as, a party can relieve their attorney. So on that basis alone, the order should be reversed. This appeal from the judgment brings up for review the denial of Plotch's motion to dismiss under CPLR 3215C. And for that proposition, I would just point the court's attention to Unigems Court v. Basco, 7080 3D 454, and Correndian, 23280 3D 690. A denial of a 3215C motion necessarily affects the final judgment. There would be no final judgment had that motion been granted. Here, it's undisputed. There was a 17-month gap between Mr. Plotch's default in answering and the bank's motion for a default judgment. So dismissal was mandatory on the 3215C. The only argument that the bank makes in opposition is, well, our filing of an RJI constitute the taking of proceedings. I was before this panel last week making the same argument. This court has long acknowledged that the filing of an RJI does not in this department constitute...
Did E-Trade make the argument that there was sufficient cause?
They did not, actually, Your Honor. They kind of pushed their chips to the middle of the table by saying the RJI constituted the taking of proceedings, so we didn't have, we satisfy the deadline is what the bank was saying. We didn't have to show sufficient cause, so they've charted their course, so to speak. They don't make that in their brief, and here I would argue, even if we could read charitably, for the sake of this argument...
Did they make that argument in the Supreme Court?
They did not. Again, their argument was, again, RJI focused, that we had satisfied the deadline because the filing of an RJI constituted taking proceedings.
What about their belief that there was a mandatory settlement conference?
That's unreasonable as a matter of law, Your Honor, because on the facts of this case, again, as this court has acknowledged, 3408 doesn't require settlement conferences in every residential foreclosure case. It's only where the defendant resides at the property at the time of commencement. The bank very well knew that the defendant didn't reside. The borrower, Mr. Del Val, had been out of title for over a year. He had been foreclosed in a condo lien. So the bank commences this case in 2013. Mr. Plotch took his deed from the condo foreclosure in 2012. So they were aware that the borrower, Del Val, no longer owned the property and no longer resided at the property. They served certainly Mr. Plotch, who the court acknowledges and the bank acknowledges as an investor, doesn't live at the property. So because this wasn't 3408 eligible, their misapprehension of law that these conferences were required doesn't constitute a reasonable excuse for the very proposition, forgive my Latin, but again, a mistake of law is not a reasonable excuse. So on this record, it's certainly not. If the court has no further questions, I'll just rest on my brief.
Thank you, counsel.
Thank you.
Beals v. Roman Catholic Archdiocese.
Good afternoon. May it please the court. Patrick Lawless for the defendant appellant, Archdiocese of New York. The Archdiocese seeks to reverse the sua sponte order.
Please continue.
Oh. The Archdiocese seeks to reverse the sua sponte order of the Supreme Court, which directed it to produce an unredacted copy of the tribunal file. The tribunal file was specifically created in connection with an internal church disciplinary process that is overseen by the DDF in Rome.
Yeah, and you make that point, very effectively in your brief, but it's being sought not on a theological question, but rather just to gather facts, is what I understand the plaintiff to be saying. So would you respond to that?
Well, it's sought to gather facts, but it's intertwined with this process. The whole point that the file was created was for this process, the laization process. And so it cannot be, I don't think it could be unraveled from that. And it's,
But they wouldn't be challenging the delaization, I'm mispronouncing that word. They're just seeking, I gather, facts that were uncovered or allegedly were uncovered during the tribunal.
But it's still part of the process, and it's connected with this process, and it would invite questions as to whether the church properly followed canon law with respect to the disciplinary proceedings.
But wouldn't those arguments be deemed out of order? I mean, aren't you speculating right now as to the proposed import of any theological evaluation?
I don't think
or
I'm
spiritual
speculating.
evaluation, however you want to put it. That's not what's an issue. The issue is whether there was a pattern response of the archdiocese, and alternatively, whether there was a modus operandi exhibited in this situation, which involves 19 related actions, all against the same now former priest.
Yeah, by reviewing the disciplinary process, though, it's going to implicate the church's internal proceedings and processes in accordance with canon law for disciplining priests. Judge Silver specifically addressed this issue in his amended confidentiality order, which was subject to appellate review by this court. And he specifically says, he's talking about discovery related to these types of proceedings. And he specifically states, inviting questions into whether a church took corrective measures by altering a priest's sacramental status and the degree which it adhered to canon law presents the exact type of situation which impermissibly require religious institution to defend its beliefs and practices. Therefore, discovery in this regard is barred.
Would you agree that in this matter where the material in question, the tribunal file, so to speak, was reviewed in camera by Judge Krause, allows her to exercise her judicial discretion as to what is material in this inquiry, in this discovery request?
But that's exactly it. That's what courts found has been impermissible, because you had a judge reviewing this material, making a determination what implicates canon law and what doesn't. And under precedent and precedent of the Supreme Court.
So you're saying that an in-camera, my in-camera inspection is a waste of time, that it shouldn't be ordered under these circumstances?
I think asking a court to make a determination, reviewing a tribunal file, what is discoverable and what's not, and what implicates canon law and what's not, I think
Is that what the court is doing, determining what implicates canon law and what doesn't, as opposed to what evidence is there that would support the charges that are being brought here?
I don't think that can be separated from the review of...
So is it your position that then, that whenever the archdiocese does its investigation, for lack of a better word, whatever it did, that they're basically immunized, that you can't touch what they do?
It's a specific process. It's an internal disciplinary process, a laization process that's done in accordance with canon law, and it's done by a specific department.
So even the facts and information that inform that process, you're saying, is shielded from review?
It's part of that process.
It's part of it. That's true.
Yeah, and to the extent that it's going to implicate canon law, I believe so. Yes.
That's the part that I'm missing. Can you explain to me how allowing discovery of the facts and circumstances that were a part of that process implicates canon law?
Because it all goes into the determination whether to remove a priest from.
No one is challenging that determination here.
But it's part of that internal process, and then it's going to raise questions of the internal church processes,
The
whether
church
they
will-
adhere to canon law.
I'm sorry, the church, may I? Please. May I? This process to get information to the court to determine the civil liability of the archdiocese, nowhere in that process will any court in New York weigh in on any ecclesiastical decision or the manner in which an ecclesiastical decision was made. The focus is the information that was used for the ecclesiastical process can or arguably be used for the civil liability issue here. There's no conflict. There's no First Amendment right that's implicated here.
Again, I believe so, because you're asking the courts to make a determination and into this process as to what is discoverable, what's not, what implicates canon law, what doesn't. And it's information that's gathered specifically with this process in accordance with church internal processes and proceedings and in compliance with canon law. And I just don't think it just implicates the First Department, and it goes down a dangerous road, I believe.
Thank you, counsel. You have time in rebuttal.
Good afternoon. May it please the court, Niraj Parekh from Slater Shulman on behalf of plaintiff respondent Stephen Beals.
Counsel, the complaint in this case asserts causes of action for negligence, breach of fiduciary duty, failure to report abuse under the social service law, and other causes of action, correct?
Yes, other negligence
Right.
related
Now,
causes of action.
nowhere in the complaint are you seeking determination regarding any religious doctrine, practice, disciplinary action, is that?
That is absolutely correct, Your Honor. And picking up on the comments and questions from the court, there is absolutely no First Amendment issue here. The information in the tribunal file, which was reviewed in camera and considered properly by the lower court, there is no abuse of discretion. She considered the First Amendment argument and rejected it, and for the proper reasons. There is no interference with any canon law or church determination. There is no challenge. There's no review. This is going to the facts that support the elements of the plaintiff's claims, primarily related to negligence and the negligence-related claims, because they have denied, one, that the plaintiff was even abused by this priest, that the defendant had any control or employment over the priest, or that they had any knowledge of the priest's propensities for abusing children. And this isn't the only one, as we know. And the tribunal file, among other documents that the court considered that are not subject to this appeal, goes to the heart of those issues. They are directly material and relevant, and that finding has no interference or implication with respect to the church's decisions or any interference with canon law.
And just to take it a step further, and certainly you're not asking for any type of review as it relates to, an ecclesiastical determination of any religious organization. Well, let's just focus on this religious organization regarding an individual's fitness to be a cleric.
Yes, I believe that that's absolutely correct. We are trying to uncover what did the defendant know about this alleged abuser priest, when did they know it, how did they know it, and what did they do? And that helps establish, one, the elements of our claims, as well as the other plaintiffs.
And nor could you, I'm sorry.
I was very interested in the court's finding that the defendants denied knowledge of any allegations.
That's right.
About now Mr. LaBelle, because if that was the situation, then the tribunal file would be about, what, 10 pages
That's
long,
correct. And
as opposed to being a proper inquiry as to whether some wrong had been committed.
that is correct. And the lower court, had said that the defendants effectively had opened the door by making such a denial. And if I may point the court to the last page of the lower court's January 29th, 2025 decision, I believe it's A17 and A18, where the court actually quotes in bold the final paragraph of one of those reports. And it states, upon investigation, it has become clear that accusations against Father LaBelle extend even to the time before he was ordained. Throughout his priesthood, there have been persistent concerns about his behavior with teenage boys. Concerns were so strong that he was sent to the St. Luke Institute for a period of 7 months, supplemented by follow-up treatment. Nevertheless, complaints continued to be made. These are the types of facts that are material, necessary, and relevant, and that's why the lower court's decision should be affirmed. Thank you.
Just one last
more question,
please. Would you agree that the defrocking process that took place, that the decision to remove him from the priesthood could never be raised at all in court? Would you agree to that?
The decision to
remove him from the priesthood.
We're not challenging that
That's
decision.
what I'm,
Yeah.
no, but to use it against the archdiocese in any way.
I don't believe so.
Well, that's a concern.
No, but there is no challenge to that issue. It's what did they know?
No, but would that be like an admission in a sense?
That they defrocked him or that they did not?
That they were aware of, that their decision to do so somehow could suggest that they had knowledge of his.
I don't think that in and of itself. I think what is going to be useful are the types of things that I've indicated. Yeah.
Thank you.
Thank you.
So, counsel, can I?
I was just going to respond to your comment before about the DKI and the answer, because this just shows, and I think it's just illustrated the problem and the issue with this is that this tribunal file was created long after the dates of alleged abuse. The complaint is alleging that the archdiocese had prior knowledge, and in order to establish their cause of actions against the archdiocese, the plaintiffs have to demonstrate that the archdiocese had prior knowledge of this particular priest's propensity for abuse. So it's conflating a denial of knowledge and information with respect to that claim with this tribunal process that happened long afterwards.
I don't know that your argument makes sense, because you either have authority over someone while that person is part of your denomination or organization, whatever that structure is, or you don't. And then the question is, to what extent does your authority go, right? So if you make a blanket statement that you deny authority or control over LaBelle, haven't you opened Pandora's box as far as the level of inquiry that invites?
I don't think so. And again, this has to do with the archdiocese is entitled to assert a defense.
I'm sorry, you're what?
The archdiocese. The archdiocese is entitled to assert a defense that they didn't have prior knowledge of this particular priest's propensity to commit abuse without opening the door to just completely unlimited discovery. One of the cases that's cited by the Supreme Court and cited by plaintiffs over and over again in support of this type of discovery is Harmon. It's a decision in the 3rd Department up in Albany, and it has to do with the Diocese of Albany. In that case, they alleged a very specific affirmative defense that at the time of the alleged abuse, their actions were in compliance with practices and procedures in effect. And based upon that, the court held that discovery requested should be turned over. But there's never been any type of affirmative defense alleged in this case. We're talking about boilerplate denials of culpability that are being used to justify broad discovery. And especially in this case, discovery of documents which implicate First Amendment protection.
Thank you, counsel. Thank you both.